Then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this code should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I got to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
engage or even consider participating in such kind of petty business.
Petty business? Then why are you asking?
Forget I even asked.
You people, you don't know what is going on out there.
What's wrong? What's going on?
Procedural has gone Ruwashi.
Huh?
Hey, he has gone banana. Garisi.
How dare you?
How dare me what?
How can you compare my executive business with that of a petty cow's business?
Like seriously, Atito, where do you think you're going?
I'm going to save the world.
Save the world from what?
From drought and starvation, of course, from Procedural.
You kill voters and include new voters. So Raila gets 48.372118662. The next page, Wahiga would get 31,098. Of the most important is the father affidavit, because when I did the first one, I did the petition, I did not have the information that came from. I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the father affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all my
Thank you. Compelling are the figures that finally mathematics finds its way into invalidating.
So, General, you have no leave to address the court after time. Why don't you start from there?
Yes.
From where? From what time? Start from there.
Senior Counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder. I will now invite counsel in petition number 6, Njuria Yokabichege and others.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mokeru for Julia Nyukafishege and 3 others. First of all, let me say that I'm very happy to be responding last, and particularly to have had that very good presentation by my long-term friend, Mr. Okiom Tata. My Lord and my ladies, the petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by 2 affidavits. An affidavit sworn on 22nd of August by Julia Shege, and a further affidavit that she swore on 28th of August 2022. We have done submissions which were filed on the 30th of August 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there are so many violations of the constitutions and the electoral law by IEBC and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the third respondent, that is the Commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The third issue that we shall be referring to is the fact that the third and fourth respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is the complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during the presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)(a) of the Constitution, voting at a place appointed by the IEBC by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts. In paragraphs 50, the petitioner says no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all this number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied in the face of how these complaints being made that those arrangements in fact were not made by the Commission. Now it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IBC has been complying with the law, but because I believe it was Judge Lenola, when he was at the High Court, made an order first that prisoners who vote in the presidential elections, and number 2 in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, the IEBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations of the right to franchise, it is a very serious thing across the world, because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, that is to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000 that directly and on account of non-compliance with an express provision of the law were unable to vote. Did the failure to make that accommodation, those arrangements to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's in my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected, would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of a presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS kit, it has been recorded, it is our submissions that on day 1, in their affidavit they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology. in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis